So it's been a busy start to the year. I'll try not to shake the computer too much. I apologize. It's been a very busy start to the year, and I hope that you guys are seeing contracts come in and buyers show a lot of interest. I know we're busy, which is great. That the market is busy. We're not seeing a ton of closings come through yet. It maybe is still a little too early for that. But there's a lot of activity, a lot of questions. There's a potential for a busy spring, but we'll just have to wait and see. But with all of those questions, we do have certain things that have come up that I'd love to address. And this is an awesome forum, and I'm so grateful to have it where you guys can come and join as available as you may be. And we can talk about the little things and kind of just spur your thinking because unfortunately I don't have all the answers. I really wish I did, but we're here with you. We're learning, and we do have our advice, and we have things that are working. So one of the things that came up recently was earnest money. And I know in some of the brokerages there have been a lot of questions. I got some feedback that some of the brokers in town, their advice is, well, call your attorney. And the issue is that a buyer is not putting in their deposit as agreed. You know, they agreed to having it due today, and then they're 2, 3 days later that it's still not out. And so the agent reaches out to their broker, and the broker says, well, talk to your broker. Talk to your attorney. That's who needs to handle it. And although I love that because it drives you guys to give me a call and my dad a call, I do want to empower you guys to make certain moves on your own. And so if we look at FAR, so FAR, the deposits are the liquidated damages. So by a buyer not putting down the deposit, that money is still very much at risk for the buyer. Obviously, that's not the case for NABOR. Under NABOR, the only risk to the buyer is the deposits that have actually been made. And that's such a huge distinction that no wonder it's a question that's coming up a lot. And NABOR complicates this further by saying that time is not of the essence for anything but the closing date. So what do you do when your buyer or the buyer is a couple of days late or one day late? And so I wanted to give you the strategy, and it's actually pretty simple, very straightforward. So day one that it's late, you warn them, you give them notice. So let's say it was due yesterday, and now we're talking about Wednesday morning. They're a day late, right? It was supposed to be due yesterday. Send an email to the buyer's agent, copy everybody on it that you have, copy the attorney, copy me, and say, we're aware that the buyer has not made their deposit or has not made their second deposit. We're giving the buyer notice that if that's not rectified by the end of the day, we intend to terminate. And that's it. It's actually that simple. You can make it a little bit more than that. You can give them a full 24 hours if you'd like, but we have to put them on notice. And the one comment to that, I can already hear the attorneys in the background, is maybe end of the day is not enough time. But if we give them notice, that's step one. You send an email. It doesn't, you don't need to call me for that. You can get it started right away. Although obviously you're welcome to lean into me and I will do that for you. So give the buyer notice that they are in default and they have till the end of the day, until this time tomorrow, to respond with the deposit. Fast forward, end of the day comes and goes, and now it's Thursday morning. You're still dealing with this issue. As far as you know, the deposit still hasn't been made. And so what would I do? I would send a termination. So this part, I think, is fascinating. I have heard several times in the last month or two that a lot of agents have never even used or seen a termination form. They've never terminated a contract. They've never seen that happen. And I think that is incredible. That means you have the best luck ever, that we're in the best market ever. This is incredible. But the reality is there are deals, and it will come up, where you will have to terminate. You'll have to terminate the contract. Luckily, there are a couple ways we can do it. One, you could do a simple amendment or a notice form and say, the seller hereby terminates because the buyer did not fail to deposit their earnest money deposit. It's really that simple, but there is a form for terminations as well. And I'm going to try and pull it up while I'm talking. But that's the key, is you have to now terminate. You gave notice, and now you actually terminate. You follow through with what they said they were going to do. So I'm going to share my screen. Do this screen. All right, so this is how I access my neighbor forms because I'm not on app files or some of those other systems. But there is a termination form, termination deposit release agreement, termination buyer notice, termination sales contract, seller notice. Let's look at this one. This is the one I like. This is really simple. This form, it provides notice to buyer of seller's termination of the sales contract pursuant to the terms of the below selected contract or addendum signed by the parties and must be delivered to buyer to be effective. So you can't just sign it, you actually have to provide it to the buyer or their broker. So fill in the buyer, seller, and property pursuant to the terms of the below selected contract or addendum. In our case, we're probably going to be, no, I don't like any of those. Sales contract, short sale. Obviously, none of those are awesome. I don't like any of those. But we can steal language from this. Seller hereby terminates the contract and requests the release of the buyer's deposit to buyer. There is no deposit in my example, so maybe this isn't the best form. Let's go back. Let's see what the other forms are. Deposit. This one I know will work for us. So on here, the termination deposit agreement, you're going to fill these things out, put the property address there. Seller and buyer hereby release each other from all rights, duties, obligations, and claims arising out or related to the sales contract. They direct the earnest money to go this way or that way. Seller and buyer hereby release all claims, obligations. It's a full termination. Maybe this isn't the right form either. I am swinging and missing. So alternatively, we could just do an amendment. And we fill out it right here and see if it lets me write in here. It's not going to let me write. Well, this class is starting out with a bang. So I'm trying to make it easy. And so maybe in this point, when you are terminating, you can reach out to me and I'll send an email follow-up after the class to verify what form I would use. But ultimately, you're wanting to give notice to the buyer that the seller has chosen to terminate. And if you need to put a reason, the reason is for failure to put the deposit, to submit the deposit. So that's a two-step process. It's very straightforward, very simple. And step 3, which is my favorite, put it immediately on MLS. Assuming the buyer was wrong, assuming the buyer has not put in their deposit, assuming everything that I've told you in this example, the seller has the unilateral right to put it right back onto the market. The contract failed, they gave them notice, they terminated, haven't heard from the buyer, or the buyer still hasn't put the deposit. You can put it right on the MLS. And there's no problems with that. Now, one feedback I've gotten on that third step is, well, the buyer's attorney is going to freak out. They're going to be losing it. They're going to be trying to sue us. And it's my opinion, I think that's okay. Don't worry about it. It's just noise, because the only thing that matters is, does the buyer put down their deposit? We're trying to create leverage. We're trying to keep the deal moving. Alternatively, if you just wait 3 days and you do nothing and you keep the house off the market, you might miss a weekend. You might miss a potential buyer who was looking, and that's unacceptable. What we're trying to do is create leverage. Now, I will give you the advice that I don't want you to accept a new contract, at least right away, before talking to one of us, before talking to your attorney. So step 1, give notice. Step 2, terminate. Step 3, put it on the MLS. Before you sign a new contract with a new buyer, lean into us, get legal advice that this is acceptable, that that contract truly is dead in the water and gone. I'll give you an example. This actually happened on a closing that we had this week. So we had a couple of things going on that were not going well. Number one, we pulled the title exam and we found a lot of probate issues. The seller had passed away a couple of months ago, and they had not finished or even started the probate to get title cleared. And probate in Collier County can take a couple of months. in the minimum. Might be more like 6 months to get things truly finalized. So when we're looking at it, it's like, well, this is supposed to close in 30 days, and they haven't even filed any probate here in Collier County. This could be a problem. And so I reached out to the buyer's attorney, and I reached out to the buyer's agent and the buyer himself. And I said, look, I don't know everything. The seller hasn't been able to give me good information. They're not responding to my comments, but just so you know, I can't imagine this is going to close in the next 30 days. So we need to start thinking. And, we send our objection to title, 30 days starts running per the contract. In the meantime, the buyer tells me that he's having a problem verifying the furniture. There's personal property. They're taking it turnkey, but an inventory list was never sent. And there was a personal property addendum. There was like a contingency for personal property added to the contract. I believe it's something in NABOR as well. And it gave the buyer the right to terminate within 10 days of the effective date if it still hasn't been provided. And so we were on day 10. And so I told him, I said, we should terminate. And if the seller can answer our questions, because at that point they weren't answering anything, if the seller can answer our questions, we'll go right back under contract. If they can help us on the probate side of things and help us understand where they are on that process, we'll get right back under contract. But you never want to give up too much leverage. You don't want to let that 10 days go by, assume that the seller is going to take care of everything, and then you're on the hook for another 30 days, 40 days, 50 days. My strategy has always been, start the process now, start the clock ticking. So in that same vein, when it comes to earnest money deposits, I don't want you waiting to notify the buyer that they haven't put in their deposit. I don't really want you waiting to terminate, but you have that option. But if you immediately give notice that the buyer is in default and that they need to cure within 24 hours or whatever you decide is relevant or appropriate, you then have that opportunity to terminate. You're reserving your right, you're reserving your leverage to terminate. So I hope that makes sense. It's a really interesting scenario. I had two takeaways from that, and this was in a call with a really great agent that I really adore. These were the two pieces of advice, and there was a third that I don't recommend. So the one that I don't recommend is adding extra language into the contract. One of the things that we came up with was you could add language that says, upon or if the buyer does not make the deposit by X date, this agreement is void automatically. There's no question of like, does the seller have to terminate or not? It's just automatically void. And the listing agent thought, that's a great idea. That kind of gives me the comfort that I need. We don't have to wait. I don't have to do all those steps. And I think he's right, except I don't want to freak a buyer out either. I don't want to have to explain new language to a buyer's agent. I don't want to make it more complicated. Instead, I think we can fix it if we just have a very quick progress along those lines of give notice, give termination. The two things I would recommend when it comes to earnest money, and I would love if you guys gave me feedback on these things or any of the other things that we've talked about so far. But number one is I don't like allowing a buyer to do an inspection without having the deposit already down. And I'm talking about the first deposit. So let's say first deposit is due within 3 days, but they schedule their inspection on day 1 or 2. And say it's a 10-day inspection period. I would not, if you're worried about the earnest money issue, if you don't have any context of who this buyer is and whether this looks like a legitimate deal or not, but I wouldn't let them do an inspection before putting down their earnest money. I think that, again, maintains leverage for the seller. You're not saying no, you're just saying, you have 10 days to do your inspection. We're not going to allow you to do it until that deposit's been made. Maybe an attorney could fight me on that. Maybe they could say we're in default, but I think what it does is it protects your seller from having to go through this inspection process for a buyer who didn't even put a deposit down. And especially if they were to break something, someone got hurt on the property, all of a sudden there's this additional liability and the buyer has no recourse. There's very little recourse because You'd actually have to sue the buyer for damages rather than just taking a deposit. So try to avoid that. And then secondarily, try to avoid going through a weekend without that first deposit being made. So I'll give you an example. Let's say you go under contract on Friday and the deposit is supposed to be due on Friday. Or let's say it's one day or it's whatever it may be. Because you're already at Friday, all of a sudden it can be Saturday. And the buyer's not in default because you need to give them notice. They can't rectify it. So you're rolling into the weekend. So if you went under contract on Friday, they have one day to send in their deposit. Really, you gave them 3 days to send their deposit and you're off the market for the weekend. So I'd say that's a no-go for me. So avoid going into the weekend without a deposit and avoid allowing a buyer to do an inspection without a deposit. If you can get those two things, you have a more secure deal. There's no guarantees, obviously, but your deal is a lot more secure. You can explain your actions. You can explain the contract in a much more comfortable way to a seller who's saying, well, why are they walking away? Or why hasn't this been done yet? And so this is my process. This is what I do with all my clients. I hope that that's helpful. I'd be curious if, and it may not be in this class, but if you want to give me some feedback over the next week, I would love to hear that and see what other little tips and tricks might be out there. But the key is we are going into a market that might not be as crazy as it was the last 2 or 3 years. And so it's more likely that a buyer won't go through with it, that they'll talk themselves out of it, that they may find some other property in the meantime and then terminate our deal. So before you kind of overdo it with your seller and ask and ask and ask, maybe put these kind of protections in place. I see a question, 10-day response, question mark. I'm not sure how to answer that, what that question is. So that's the big question I saw. We had another thing come up recently where people were questioning the closing process. So this is part 2 of this conversation. And it's really about understanding what we do and where we add value and the closing process and title insurance and things of that nature, as well as the estoppels and property taxes. And the key on all these things and how to explain it to your client is that you want to do a full search of the property. You want to make sure that you can trust and believe in the transaction, that it is above board every step of the way. And that is our job. Our job is to make your client feel comfortable about the process, to feel comfortable about what you put together, to know that we've done the research, we've looked into the property, we've gotten estoppels and summaries, and that we're insuring it, and that we think that this is normal, inherently normal. And that's our job. The key is to make your client feel comfortable, whether it's a buyer or a seller. And secondarily, or simultaneously with that, it should be to make you feel comfortable. Because I feel like my number one job is to make you feel normal, make you feel like this isn't a huge problem. And if I can do that for your client, then and I can do that for you, then I've been successful. And someone asked me recently, do attorneys have to be real estate board certified to do what I do? And the answer is no. There are really great attorneys that are real estate board certified, but I think the key is making your clients feel comfortable. It's your bedside manner. How well do you know the contract? Can you advise your client in the right way to keep deals together, to keep them happy and excited about the transaction? I think that's really, really important. All right, so going back, I got a clarification on the question. So the question was in regards to second deposits. And so I love this, and it's something my dad's talked about ad nauseum, and it's wonderful. And I think you should all use it, but it can also be used against you. So you need to be aware that it's out there. It's in regards to the first deposit's been made, the inspection has been performed, and the buyer has made their elections. The seller at that point is going to need to respond. However, the seller has 10 days under the neighbor contract to respond to a buyer's election request. So a buyer finds that the GFCI outlets are all defective and asks that the seller replace them all, or asks the seller to give them a credit and attaches an invoice from an electrician. The seller does not have to respond right away. They have 10 days from the time the buyer makes their election. In the meantime, and this is what my dad was always getting at, is that in the meantime, your second deposit is likely made or needs to be made. So let's say the second, it's a 15-day due diligence. Buyer election is on the 15th day. The seller has 10 more days to respond, but the second deposit is due on day 16. I would not rush, and this is my dad's recommendation. We don't rush to respond to the buyer's requests unless we're just going to say yes. So we're going to say yes to everything. You can go ahead. I don't see where you'd be giving up much leverage, but wait for the buyer to submit their second deposit before responding, because there might be something that the buyer expects to be taken care of, but it's not actually a defect. And say it's mold. So it's mold, it's penicillin aspergillus, it's not a defect under neighbor contract. We want the buyer to make their second deposit before educating them about that, before we respond and say, yes, we will do the remediation of the radon, we will fix the GFCI outlets, but oh, by the way, penicillin aspergillus is not a defect in the contract, and we won't be addressing that under the contract. If the buyer's already made their second deposit, they have a lot more on the line. They're not, most likely, if the deposits were significant, they're not going to walk away at that point. And so you're more likely to keep the deal together. So a really key point. But remember, use that when you're a buyer as well. Know what you're trying to accomplish. So if you put it out a contract and you're making the offer and you say 15-day due diligence and the second deposit is due on day 16, I don't love that for you. I think you could get pushed. So the only other workaround on that is if you did your inspections and buyer election on day 4. Or day 5. So you do all your buyer elections and inspections by day 5, seller has to respond to you by day 15, and the deposit's not due till day 16. I think that'd be really great. Alternatively, if it was a 10-day due diligence and the deposit's due on day 20, the second deposit, then you're kind of resolved from that as well. And then a third option would be if you used an as-is contract, or even if you looked at a FAR-BAR contract. The FAR-BAR treats it very differently than NABOR does. So it's a really intriguing strategy. It's one of those things that the more we do these deals, the more that we get invested on these kind of strategy ideas and how could we have done this a little bit better? And there's so many things in this business where you think you've got it figured out until you don't. I always said the probate issues and divorce issues and liens, I always feel like I have a good solution, and then the next one throws me for a loop. But this one is pretty solid. Knowing when your seller is going to respond so that you can plan your second deposit. Always try and be in the driver's seat on that one, whether you're a buyer's agent or a listing agent. And if two people on this are on the same deal and they're buyer and listing agent, then I apologize. You just have to work it out together. You'll have to figure that one out and figure out which one is fair to make sure that the deal goes through. The big 3, as I called it last week: get under contract, protect your client, get it closed. That's the best way we can keep these deals going and keep your clients keep them coming back. One last thing. I mentioned briefly probate. Just as a summary as to what probate is. And I think this is really an interesting piece. When you own a house, let's say it's an individual owns a house. I own the house. I'm only one on there. I'm not married. I pass away. It will go into my estate if I own it in my individual name. So if on the deed it says Christian Ross, then it will go into my estate upon my death. In order to sell that property, the listing agent would need to verify that the estate has been probated. It's a verb. I was always questioning whether it's a verb, but it is. It's gone through the probate court, and number one rule for the probate court is to verify that we have, there's nothing weird going on with this estate, that it has been, the will has been submitted, that it is the correct will, that there are no heirs that have been left out, that everyone has signed off on it, and there are no creditors that we have to worry about. And then after the judge and the court has verified all of those items, they'll sign off on it and say, all right, Tom will be the executor for the Christian Ross estate. And at that point, those are the letters, testamentary, or some version of that. At that point, the listing can be sold. It can be actually closed. Anything short of that means that you're not closing. If it's in someone's personal name, they've passed away, and probate's not been completed, you're not closing. And like I was saying earlier, Collier County can be 3, 6, 9 months. Unfortunately, one of the big issues that we see around here is that they might pass away up north, and then they probate the estate up north, and they don't realize they also have to probate it down here in Florida. In order for us to rely on an order, we want to make sure that it's a Florida judge. So there are a couple of workarounds to that. If it's in a trust, if they are husband and wife listed on the deed, or joint tenants with right of survivorship, and there's a surviving spouse, or the surviving joint tenant is still alive, then we don't have to go through probate. The property would automatically move over. It's really messy. I would suggest, before you take on a listing, call. Let me look at it. Let me pull the most recent deed. Let me help you with it. We can also look at permits. But if, let me give you an example. This is the easy way for me to do it. Every time I do examples, it kind of backfires, but let's try it again. All right, so this is one of my favorite websites. It's the Collier Appraiser website, collierappraiser.com. Lee County has the same thing. It's leepa.org or .com. Let's find out. leepa.org. So this is the Lee County one. They're both very similar, but we're going to search for me. There are a lot of Rosses. We're just going to go to my address. So you can look at the tax record and who's listed. You'll see 2 people on there, but go a little further down, and right here it has all the deeds down on the bottom left. Going back to 1982, it has a copy of the deed from 1982. The interesting part on this is Nancy B. Parker individually, in whatever capacity she may be construed to have as co-trustee of the trust, to Dudley Godfrey Jr. and William B. Murphy as co-trustees of the Nancy B. Parker Irrevocable Trust. So let's say you get word that Nancy has passed away, and you start asking, well, has it been through probate? Has it been through probate? It didn't need to go through probate. In fact, most likely. In fact, it looks like it's held in a trust, the Nancy B. Parker Irrevocable Trust. And so the only other question you would have is this homesteaded property? If it was homesteaded property, then we might still need some probate. We might need to verify, if there's a surviving spouse or something like that. But this is wonderful. So if you were to pull up the most recent deed where I took title, you would see here Christian Neil Ross and Jessica R. Ross, husband and wife. And if I were to pass away and you're meeting with my wife to sell the house, you'd have this deed with you, and you'd be able to have a conversation with my wife and say, do you have a copy of Christian's death certificate? You're going to look like a superstar. You're going to absolutely look like a superstar. In fact, you can go even further into it on this website, and you can pull permits. It's not going to tell you whether they were closed or if they're expired or anything like that, but it's really great information. You can pull the most recent tax records. You can see, in fact, if there was a homestead exemption. You can see it right here. I think you can see my my mouse here, but it's showing an exemption, 50,000 on the county tax portion. So that means, yes, it is my homestead. There are other ways you can look as well. Another thing that I think is really cool about this website is if you push the tax bills section, and this is a this is something that I've been using a long time, so I'm very quick with it. If you have questions, call me. But tax website is great. You've got the tax appraiser and you have the tax collector. The collector is the one who actually bills you. And if you pull the most recent bill, you can pull it right here. You can see what the exemption is. You can see over here, additional homestead and the regular homestead. But if you go back, if I can find it. This part, I think, could be a reason for you to reach out to your client, get bills by email. So I typically bring this up in a closing, and the clients usually love it because I'd say the majority of our clients have two homes. They might be up north and down here, and they don't want to miss a tax bill. So I'll go on here for them. I'll fill in their email, and down here, I want to receive a paper bill in addition to my e-bill, and I am the current, or I am the owner of this property. That's the one I usually select. You push continue, you'll get an email sent to your email address to verify, and then you'll start getting the electronic bills. Every November, you'll get the electronic copy of it. I think it's great, and it puts your client's mind at ease in regards to paying their taxes. And it might give you an opportunity, if you look through the last 36 months of closings and the clients that you've had, this gives you a reason to reach out to them. This, you can reach out and say, hey, I noticed, you still have the bills being forwarded to your address in Wisconsin. Would you like me to sign you up for e-bills so that you can get them by email? And that way you'll never miss it. I think that could be a really cool marketing opportunity, and I wanted to make sure I shared that with you. They also have fraud alerts on Collier County and Lee County. So if you put in your name, you can do it for yourself. You put in your name, and if anything with that name is recorded in that county, you'll get an email. Now, it's after the fact, so it's not going to be a foolproof plan of preventing someone from stealing your identity, but it at least gives you very quick notice if someone's filing a lien against you or a mortgage or someone with a similar name. So I hope that was pretty cool. I think that website is wonderful. I do have a couple of questions. Can you email us the strategies of the second deposit? Absolutely. Happy to do that. I will send you guys a strategy. And then I had another question. This one is an interesting one. What if it's an LLC? How many people need to sign? Wonderful question. Okay, so number one, we will be sending out an email. If it's not this weekend, it'll be next weekend, talking about who signs. We do have a previous article, I think we wrote in 2018, talking about who you need to sign. The LLC portion is very interesting. The best answer is that all the owners need to sign. That's the simplest thing. But that may not be what's required. There might be a minimum, like the manager might be able to sign, or the majority of the owners may be permitted to sign. We have an example that we wrote in this article that's going to be coming out, talking about where there was a sale of this LLC's assets, and the majority of the owners said yes, and a minority owner said no. Legally, that was enough. That should have been enough for the closing to happen. But that minority owner sent a letter, certified letter to the title company that was doing the closing saying, I object to the sale of this home. And that was enough to kind of put a pause on the closing. So the best answer, I know that was a little long, a little overdrawn, but get as many of the owners as you can, if not all of them. And short of that, get a copy of the operating agreement and send it to me and I'll look at it for you. I'll tell you exactly who I need to sign. We'll read the agreement that they have. And if they don't have an agreement, then everybody needs to sign, everybody. Just remember, for who needs to sign, homestead is a big game changer. So if it's a homesteaded property, the best answer is get everybody. If it's non-homestead, then we can probably rely on some other some minority or less than less than everybody. Secret asks, is there a website where I can see the progress, how the probate property is moving along? Yes and no. You can actually go on the probate court website and you can see all the filings that have been issued. It's not going to necessarily give you a quick, 88% and expected completion May 1st. It's not going to do that. But we can certainly pull all the filings. We can see the most recent motions and see if is the judge asking for more stuff? Are we just waiting some sort of time frame? Has the petition been filed? So yes, but that's the answer to that. And to clarify, the article for who went to sign it went out Sunday. So actually, you can go look at that one. So thank you for coming. That was about 40 minutes, so that was perfect. If you guys need me, please contact us. You can call myself, you can call my dad, call the front office, and they'll find us for sure. But I really enjoy these classes. I wanted to thank you. We'll keep doing them. 2023, maybe we'll do them every week. That would be awesome. So I wish you guys luck, and we'll see you next week. Bye.